Hello friends, how are you all? Welcome back to my channel. Today I will talk about a very important matter, that is the difference between Indian Penal Code IPC and CRPC Code of Criminal Procedure. Now let's start. Laws in India are divided into two categories, one substantive law and two procedural law. Indian Penal Code IPC is a substantive law and Code of Criminal Procedure or CRPC is a procedural law. अब आते हैं सब्सटेंटिव लॉ पर. द सब्सटेंटिव लॉ इज अ स्टैट्यूटरी लॉ that defines and determines the rights and obligations of the citizens to be protected by law. Now the procedural law. Procedural law or adjective law deals with the enforcement of law that is guided and regulated by the practice, procedure and machinery. Procedural law prescribes the means of enforcing rights or providing redress of wrongs and comprises rules about jurisdiction, pleading and practice, evidence, appeal, execution, judgment and the representation of counsel, costs and other matters. IPC or Indian Penal Code is also known as Bharatiya Danda Sanhita in Hindi and Tazirate-Hind in Urdu language. IPC was enacted in 1860 and it came into force in 1st January 1862. There are 511 sections and 23 chapters in Indian Penal Code. It defines offences and it prescribes punishment. When an offence committed, police used IPC to make charge sheet. On the other hand, CRPC or Code of Criminal Procedure, इनको हिंदी में हम दंड प्रक्रिया संहिता के नाम से जानते हैं, and CRPC came into force on 1st April 1974. CRPC has 484 sections, 33 chapters and 2 schedules and 56 forms. CRPC deals with the investigation, interrogation, evidence collection, arrest, trial, bail and etc. CRPC is a procedural law and it deals with implementation of substantive laws and other machineries. IPC or Indian Penal Code 1860 is the principal criminal code of India that defines crimes and provides punishment for almost all kinds of criminal and actionable wrongs. On the other hand, CRPC is the procedural law, as I am told about, that provides a detailed procedure for punishment under penal laws. Who wrote the Indian Penal Code and Criminal Procedure Code? Thomas Babington Macaulay. IPC and CRPC were introduced in the year 1861. These laws were codified by Thomas Babington Macaulay, who was the law member according to the Charter Act 1833. These laws were introduced by Lord Canning in 1856 to 1861. As citizens of India, it is important to be well versed with the laws of our country. More so when it comes to society at large, the criminal laws impact not just individuals but the entire society. The Indian Penal Code or IPC and Code of Criminal Procedure CRPC is in the year 1834, First Law Commission of India was appointed. Its chairman was Lord Thomas Babington Macaulay and 4 other members. There are some tasks of that commission. The Law Commission held the codification of penal laws in India, the law applicable to non-Hindus and non-Muslims, and the codification of civil and criminal procedural law. This draft of IPC was prepared in 1837, which became a law in 1860. Indian Penal Code is mainly the work of Lord Macaulay, and on account of it, it is called the Macaulay Code. On the other hand, the Code of Criminal Procedure is the main legislation of India, which tells the procedure for the implementation of criminal laws. For example, investigation of crime, apprehension of suspected criminals, collection of evidences, and the determination of punishment of the guilty. Now let's talk about the main differences between the Indian Penal Code and CRPC. The Indian Penal Code is the official criminal code of India, which was drafted way back in 1860. IPC and CRPC both are two most important legislation governing crimes in India. Besides this, the Indian Evidence Act 1872 is the third legislation under criminal law in India. The Indian Penal Code is the official criminal code of India, which was drafted in 1860, and its objective is to provide a general penal code for the country. It has 511 sections and across 23 chapters, providing the list of crimes along with their definitions, punishments, and the IPC has been amended several times also, and it is now supplemented by the other acts. Its jurisdiction extends to the whole of India except the state of Jammu and Kashmir. Now let's know about the Code of Criminal Procedure or CRPC. The Code of Criminal Procedure is the main legislation of the procedure for the regulation of criminal law in India. The CRPC details the procedure for the legislation of the crime, presenting criminals before the court of law, collection of evidences, determination of the guilt or importance of the accused. CRPC also determines the guilt or innocence of the accused and imposition of penalties or punishments, etc. It further lays down the hierarchy of the courts competent to try criminal lawsuits. In descending order, it is the High Court at the top, followed by Session Court, First Class Judicial Magistrate, Second Class Judicial Magistrate, Second Class Judicial Executive Magistrates. There is a limit of fixed for sentences that these courts can pass against the accused. The Supreme Court is the apex court and it has the ultimate power. The code was enacted in 1973. At present, the CRPC contains 484 sections and across 37 chapters, and it also has the 2 schedules and 56 forms. Major differences between the Code of Criminal Procedure and Indian Penal Code are: IPC provides a substantive list of all crimes and also lays down the punishment for each one of them. For example, Section 378 defines theft as whoever intending to take dishonestly any movable property out the possession of any person without the person's consent moves that property in order to such taking. It's said to commit theft. The punishment for the offense of theft is spelled out under Section 379 in the following words: whoever commits theft shall be punishable with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. On the other hand, CRPC is a procedural law and it lays down the ways or methods to be followed in a criminal case. So if a person is charged with theft, it is the CRPC that provides further details as to how the investigation would be carried out and how evidence will be collected, etc. So, Code of Criminal Procedure or CRPC concerns itself with the procedural aspect of the crime. Secondly, the primary purpose of the Indian Penal Code is to provide a general penal code for India which prescribes punishment to wrongdoers. The primary goal of CRPC is to consolidate the criminal law in the country. The Indian Penal Code is a substantive law, whereas the Code of Criminal Procedure is a procedural law. Now come to the conclusion of this topic. The Indian Penal Code, Code of Criminal Procedure and the Evidence Act are the 3 primary pieces of legislation governing criminal laws in India. They continue to play an important role in the court of law for the effective administration of justice. Besides this, there is other legislation such as the Prohibition of Child Trafficking Act, the Juvenile Justice Act, which supplements the 3 main legislations. Both the IPC and CRPC are pan-Indian in nature and extends to the whole of the state, but not the Jammu and Kashmir, and Jammu and Kashmir are beyond their jurisdiction. IPC is the only substantive law here, and the Indian Evidence Act and CRPC are the primary laws. Dear friends, if you like today's content, please don't forget to like, comment or subscribe the channel. I will be back very soon with a new topic. Till then, bye bye.